The Supreme Court took up a subtle question about who gets the benefit of newer, lighter penalties under a law called the First Step Act. The question wasn't a big headline grabber. It was about whether a prison term counts as imposed if a judge later wiped it away. The justices said that if a sentence is vacated, meaning it's erased, it's treated like it never happened. That little detail means anyone who had an old sentence thrown out and needs to be resentenced now gets the chance to avoid harsh, stacked minimums that used to hit first-time gun offenders with decades behind bars. Justice Jackson, writing for the majority, noted that this reading lets people who went back to court after the law changed get the newer rules. 4 other justices joined her opinion, while 3 judges on the other side, led by Justice Alito, disagreed. After the break, we'll explain what this could mean for folks still waiting to see if they get a shorter sentence under these updated guidelines. Stay tuned. 9 Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided, it's about why those decisions matter. To give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. In 2009, Tony Hewitt, Corey Duffy, and Jarvis Ross were convicted of bank robbery and related firearm charges in Texas. Under the mandatory stacking rules at that time, they received extraordinarily harsh sentences exceeding 325 years. After some convictions were vacated on appeal, they were resentenced in 2012 to 285 to 305 years. Following a 2019 Supreme Court decision that invalidated part of the law's definition of crime of violence, the defendants successfully challenged additional firearm convictions. The district court vacated all their firearm convictions and ordered new sentencing hearings. At these hearings, they argued that the First Step Act of 2018, which reduced mandatory minimums for firearm offenses, should apply to them because their previous sentences had been vacated. The act made these reduced penalties retroactive if a sentence has not been imposed as of December 21, 2018. Both the District Court and the Fifth Circuit disagreed, ruling they were ineligible because they had been sentenced before the act's effective date. The Supreme Court agreed to hear the case to resolve this issue. Justice Jackson delivered the court's opinion, joined by Chief Justice Roberts and Justices Sotomayor, Kagan, and Gorsuch. The court held that under the First Step Act, a sentence has been imposed only as long as it remains in effect. Once a sentence is vacated, it is legally void and no longer imposed for purposes of retroactivity. The court's analysis focused on Congress's choice of the present perfect tense, has been imposed, rather than simple past tense, which indicates continuing legal effect. Established legal principles confirm that vacating a sentence nullifies its ongoing operation, placing a defendant in the position of someone who was never sentenced. Accordingly, the defendants whose pre-act sentences were vacated must be treated as if no sentence has been imposed as of the First Step Act's enactment and should be resentenced under the Act's more lenient 5-year mandatory minimum. The court reversed the lower court's judgment and remanded the case. Justice Jackson, joined by Justices Sotomayor and Kagan, also wrote additional sections reviewing the political and legislative context, widespread judicial criticism of the harsh stacking penalties, the Sentencing Commission's calls for reform, and Congress's compromise in granting limited retroactivity. These sections highlighted the statute's objectives, balancing finality with ending excessive sentences, but didn't add new legal reasoning to the binding textual holding. Justice Alito, joined by Justices Thomas, Kavanaugh, and Barrett, dissented. He interpreted the phrase, "a sentence has been imposed as of enactment," to refer simply to the historical fact that a defendant was sentenced before December 21, 2018, regardless of later vacature. Alito argued that imposed refers to the court's pronouncement of judgment, and a sentence is indefinite, meaning any sentence at all, and need not be presently valid. He rejected the majority's vacatur rule, noting that neither common law nor precedents treat vacated sentences as never having occurred. He would have held the defendants ineligible for relief because each had been sentenced before the act's effective date. The key legal question centered on Section 403B of the First Step Act, which states that reduced mandatory minimums apply to pre-enactment offenses if a sentence for the offense has not been imposed as of such date. The majority emphasized Congress's deliberate choice of the present perfect tense, has been imposed, unlike nearby provisions using simple past tense, signaling that only sentences still in force on December 21, 2018, would prevent retroactivity. This interpretation aligns with established legal principles. A vacated sentence is legally void and has no continuing effect, treating the defendant as if never sentenced. By limiting retroactivity to those without valid sentences on the act's effective date, Congress balanced the general presumption against retroactivity, the interest in finality of judgments, and the bipartisan goal of ending disproportionate stacking of firearm sentences that had resulted in extreme prison terms. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.